SJC 13412, Fairhaven Housing Authority v. Commonwealth.
Okay, Attorney Randazzo.
Good morning, Chief Justice Budd, honorable justices, may it please the court. My name is Michelle Randazzo for the plaintiffs' appellants, Fairhaven Housing Authority, and others. With the court's permission, for consistency with the parties' briefing in this matter, I will continue to refer to the agency as DHCD as opposed to its current title of Executive Office of Housing and Livable Communities. Thank you. How far is too far, Your Honors? That's the case that we posit is presented in this case. The court well knows that administrative agencies only have as much authority as the legislature gives to it and no more. And the courts routinely serve as the gatekeepers against administrative agency overreach. Thus, inherent in almost every legal challenge to regulations, rules, policies, guidelines, challenges to administrative agency action in that regard, when does the agency cross the line between what the legislature has delegated to it as authority? That's inherent in every case.
So here the legislature has delegated the authority to strike contract provisions that do not conform to the guidelines. Why is that not clear?
We're not saying that's not clear, Your Honor.
Okay.
Here's our read of Section 7A. First off, it's 3 sentences long. The first sentence says, the agency shall promulgate guidelines for executive director employment contracts. Okay? Prior to the adoption of this statute, the HCD had its own regulation that said, if a housing authority and an executive director shall enter into an employment agreement, the HCD shall approve and shall set standards for the guidelines for the standards of such approval. What existed, therefore, at the time that the legislature enacted Section 7A were exactly what we call guidelines, parameters, minimum qualifications, minimum hours of work, salary ranges. And that was, and the legislature's considered to have known that landscape when it directed.
And that didn't work very well, right? Because we had we had the disaster where someone, I can't remember, he was making 3 or 4 times the amount he was supposed to make, and it was all hidden, right? Exactly,
Your Honor. That is exactly the point. And our read of Section 7A is that it was a mandate to DHCD to do better, not necessarily to go beyond what, and actually do what it did, and I'll talk about the substance in a minute, but guidelines don't have the force of law as regulations. We all know that. As this court said in the main opinion, and I think more forcefully in Justice Botsford's concurrence in Global NAPS, agency guidelines can't create or impose obligations beyond what the statute affords.
Unless the statute intends that it does. Unless that's what the intent of 7A was. So put aside for a minute the internal management exception issue on regulations. And sure. I know you'll get to it, but just put it aside for a second. What you've got is you've got 7A drafted knowing about Section 7. And you've got the issue that happened in Chelsea. So why can't the legislature decide to delegate to the agency that they are going to deal with salary at the local housing authority through not regulations but guidelines, and that the guidelines give the delegation gives the agency the ability to do that?
We don't disagree with that, Your Honors. What we do disagree with is how far those quote-unquote guidelines went. And we think that that's one of the fundamental flaws with the lower court's dismissal of this case, is that there's no apparent review of those actual guidelines. And I think it's very important, we've included them in the addendum, to show exactly what it is that these guidelines purport to do.
How do the guidelines go beyond the authority? Can you just identify that?
Absolutely. They dictate every single term of an employment contract. They've drafted an employment contract.
So what term are you concerned about that's dictated?
So there's several terms, and I will first start off with...
Give me one.
Okay.
Any.
Something. Mandatory arbitration for any dispute under the contract. Where is the authority for that under Section 7A? Precluding executive directors from receiving benefits that they had received or that their other employees receive either throughout their tenure or as part of a negotiated contract prior to the enactment of Chapter 235 of the Acts of 2014.
So how does mandatory arbitration, just to stick with one, violate 7A?
Okay, first off, it is not a term that deals with remuneration. And our view of Section 7A is that is the focus of Section 7A.
Where does it say that in 7A?
It says, the second sentence says, DHCD may review all employment contracts funded with state dollars, but shall review all contracts worth more than $100,000 per annum.
But where does it limit the authority to only issue guidelines with regard to remuneration?
So again, as was mentioned by Justice Kafka, the prelude, if you will, to the legislative
Yeah, I'm
amendment.
just sticking with the text for now.
Right,
And
so-
then you can get to the prelude later. But where in the text of 7A does it say that the agency is limited to promulgating guidelines that deal with remuneration?
Those two words are not in the
Okay,
same
so
sentence
let's
together.
go back to your example on mandatory arbitration. How does that violate the 7A?
Because under Section 7, the Board of Commissioners of any housing authority have the authority to determine the terms and conditions of employment, including the choice as to whether or not to even enter into an employment contract at all. Okay? Mandatory arbitration, for example, and this isn't before you on the record because this was dismissed on a motion to dismiss, but something like that is a policy decision by any public sector employer as to whether or not it was choose to negotiate that term with an incoming or a continuing executive director. From a employer perspective, and I represent public sector employers all across the state, I'd never agree to that. And there's policy reasons why.
This is a different animal in the sense that we've got going all the way back to the 1970s, the Medford Housing Authority and West Broadway, and the nature of the relationship between the housing and development and the local housing agencies.
We of course acknowledge the pronouncements of this court from the 1970s, both in the West Broadway Task Force case and the Medford Housing Authority case. But I think they also have to be looked critically in context, okay? Those cases cited to specific statutory provisions of 121B, as well as regulations that delineated the different types of authorities in coming to the conclusion that this agency has oversight authority. But similar to the Department of Education and Elementary and Secondary Education, they have broad oversight authority over schools, but school districts are not arms of the state entity, and neither are local housing authorities arms of DHCD.
But the first sentence is so specific in 7A. DHCD shall promulgate guidelines for contracts to be executed by the LHA and an executive director. I mean, that's very, and we know it's passed in response to basically, cute contracting with executive directors. And then the third says, provided, however, shall review all contracts and all terms for payments or monetary remuneration worth more than $100,000. Again, and then you got the killer sentence: may strike contract provisions that do not conform to the guidelines. I mean, it's hard to be more specific than that.
So to that point, Your Honor, certainly, if under the guidelines that existed prior to the challenge guidelines here, there were salary ranges based on housing authority size.
But that didn't work. That clearly was avoided. And the legislature and everyone else was embarrassed by that. So they tightened the noose.
And that's legislative history, I think, could show not only that, but who was the focus of that tightening the noose.
Executive directors.
I disagree, Your Honors. I would say that it was, in fact, DHCD, to pay more attention where they had already previously had that authority, and a record, if developed, which, again, this was on a motion to dismiss, might show that, in fact, executive director contracts were submitted to the agency and routinely, or at least not infrequently, not acted upon for years, if ever.
Well, but they were blown by them. They were, because the guidelines weren't specific enough before, that this Chelsea Housing Executive Director Agreement slipped through, and no one noticed it.
Through affirmative criminal misconduct for which he was jailed.
Right.
So it's a one bad apple in the bunch, right?
I get it, but then they said, we're gonna err on the other side. We're gonna police this really carefully.
And then we go to how far is too far.
Well,
Again,
counsel, if the provision that Justice Caffrey just read to you said, shall promulgate regulations, would you have anything to say? Would you just lose?
Well, if they were promulgated, our position is that if they wanted to go as far as they did, at a minimum, those would have had to have been promulgated as regulations.
You needed
because
you needed the word regulation and then
Yes.
in conformance with 30A.
Absolutely.
Okay.
Absolutely, Your Honor. Because, this court has well recognized the value of the public notice and comment period.
That's
One-
because it involves the public, right? That the 30A regulations deal with matters that aren't just purely internal, right? The AG's brief makes that point pretty clearly. And it takes a huge amount of time to get through the regulatory process, or at least some amount of time. And this was an emergency, and they could pass the guidelines right away, and they related to internal matters. Again, that within the power of the legislature to do that?
Okay, just a couple of factual points. These guidelines were not passed right away. It was almost 2.5 years after the legislation was passed. They were changed repeatedly when it was drawn to their attention that at least one of the provisions that they had in this mandatory contract violated other provisions of state law.
To address the part about the internal aspects of this, though, I think that that's the key as to whether or not 30A applies.
Well, and that argument, of course, was just raised at this point, was not raised below. And
So is it your position that's not proper before us?
I think that it would require more fact-finding, as this court has said before, that the various pieces that go into an analysis of whether or not something is in fact internal management requires, I would say, more facts than what you have on the record before you right now. In order to accept that argument, respectfully, Your Honors, you'd have to accept the notion that local housing authorities and their executive directors, who are constituted under statutory scheme, elected in most instances by the populace of the community in which they serve, that those people are essentially arms of DHCD. And
No, they're the opposite. Actually, they have such independent political power that you need a countervailing force to monitor and regulate them. Isn't that what happened in Chelsea? He had a power base, and that's fairly common for these executive directors, right? They're political figures from each town, often, and they were concerned about how much power they had, and they needed to be regulated.
I'd suggest that we don't have that on the record before you, and I would have any number of small housing authority executive directors testify to the exact opposite if we were in that position.
Mm-hmm.
But I think, again, our main point is guidelines are guidelines. The common sense usage of the word
What is a
not...
guideline that the agency can strike provisions that do not comply with the guideline?
So, perfect example, Your Honors. Here's our salary range. If you are a housing
Oh,
authority
well, what
of
if
this
I say
size-
the guideline is a maximum of, I don't know, 198,000?
Right, and in
That
fact...
would be okay?
Yes, I mean, look, 4 years, I will acknowledge that...
What if
that-
my guideline was, I'd like these things to be arbitrated?
I disagree.
Disagree with what?
The idea that that is permissible within the set of guidelines.
Yeah, so tell me why that one doesn't work. Why can't
well-
I have a guideline that says arbitration? That's what I want.
Well-
And then you show me a contract that doesn't have arbitration, and I look at 7A and I say, look, I have the authority to strike contract positions that do not comply with my guidelines. So I'm going to strike that one that says no arbitration.
First off, the department is not, and I don't think that they would argue to be, have any particular expertise in the field of public employment contracts, number one. Number two, the terms that they are asking to include well go beyond guidelines. They've mandated, for example, that executive directors must be fired in certain delineated circumstances, and that in fact, the employment agreement, this is the language they require, that the employment agreement will terminate upon a conviction of any misdemeanor or felony, regardless of whether it's attached to the executive director's employment.
The
Okay?
issue, though, is what guidelines means in this statute. And when the legislature passed 7A, they were aware of the APA and didn't use the word regulations. So it
And that has significance, Your Honor. I mean, there's not a case that the agency has cited, nor am I aware of any particular case that says because it's easier for an agency to more fluidly, I think as they characterize it, to adopt guidelines, that therefore means that those guidelines can say whatever the agency wants precisely because it's easier for them to do it on the fly.
Could you quickly just address the internal management and exception for discipline exception and how Commonwealth versus Tuttle and the sobriety stop points are somehow different than this situation?
Again, because, and of course, this court knows that there's sparse case law in this internal management exemption. I don't think that the analogs to federal cases is particularly helpful because the wording is more precise. But those cases involved efforts by state agencies to regulate those people, their employees, their personnel.
But the public's being stopped at the sobriety stop points in Tuttle.
And because, I think, Trumbull, maybe? I think that the issue there was it was directing the state troopers on how they perform a function that they'd already performed, and it was giving more definition, if you will, into how they performed their duties. These were state troopers. These were folks that worked for the state, for the agency that promulgated the regulations at issue. It's very clear that local housing authorities and their executive directors are separate legal entities. They are not arms from the state. And again, we respectfully request that this court critically look at what is framed as guidelines, because they aren't guidelines, they're mandates, and mandates that go to such an extreme that they ought to have been at a minimum promulgated as formal regulations. If there's no other questions, thank you, Your Honor.
Thank
Your
you.
Honors.
Okay, Attorney Haskell.
Thank you. Chief Justice Budd, and may it please the court. We would make two basic broad points in this appeal. One is that what the department has done with in the public housing notices that are at issue here is fully consistent with Section 7A and what the legislature intended for the department to do when it enacted Section 7A. And then second, what the department has done is consistent with Chapter 30A in the Administrative Procedure Act. As to Section 7A, it does come down to the terms of the statute that we've already spoken about during this argument. First sentence of Section 7A provides that the department shall promulgate guidelines for contracts. It doesn't say guidelines relating to remuneration terms of contracts or any other particular terms. Guidelines for contracts. And we know that that is intended to mean contractual terms beyond just compensation from a statute that was enacted at the same time as part of the same legislation, specifically Chapter 121B, Section 26B, subsection D, the very last sentence of that statute, as part of the same housing reform, housing authority reform legislation in 2014, the legislature created a program supervised by DHCD to identify and correct chronically poor performing housing authorities, including...
They're not saying you can't promulgate guidelines. They're just saying that if you want to go as far as you're going, you need regulations that comply with 30A.
Well, and again, I think as I understand Ms. Randazzo's argument, I may be misunderstanding it, as I understand Ms. Randazzo's argument, she seems to be arguing that where Section 7A says guidelines for contracts, there's some subject matter restriction in there, guidelines for these parts of contracts but not others. And what I would direct the court's attention to is that very last sentence of 121B, Section 26B, What that says is that under certain circumstances, the department is authorized to terminate the employment of an executive director in accordance with that person's employment agreement with the authority as approved by the department. What that last sentence of Section 26B indicates, what it contemplates, is that executive director employment contracts that are approved by the department are going to have a termination clause, and therefore suggests that the legislature envisioned the scope of the guidelines under Section 7A as not being limited to just compensation or remuneration. Rather, Section 7A ought to be taken at face value, at its plain language. Guidelines for contracts means guidelines for all aspects of contracts.
So assuming we agree with that, it does not limited to a particular aspect of the contract, why doesn't guidelines mean something other than rules or regulations?
Sure. Guidelines, as we know, unlike regulations, is not a defined term. In the Administrative Procedures Act, we really have two reasons that we would suggest why this isn't subject to the Administrative Procedures Act, because it falls under the rubric of rules and regulations. One is that the Administrative Procedures Act, Chapter 30A, has been on the books for 70 years, the mid-1950s. The legislature knew it was there when it enacted Section 7A and chose in Section 7A to say something different. Guidelines that we know from the last sentence of Section 7A are going to be enforceable because the department is going to strike contracts that don't comply with the guidelines.
But when they do that, when they add the last sentence to the first sentence, do they convert guidelines basically into regulations without going through the APA?
Our view, Your Honor, is that the better way to view Section 7A and the way to really harmonize the entirety of Section 7A with the APA is that what the legislature intended to do here was create an exception to the Administrative Procedures Act. What the legislature here is authorizing the department to do.
Normally they do, notwithstanding any or to the contrary, we do this. They kind of don't do that here. It's a little odd, right?
I'm sorry, say that again.
I mean, when the legislature tends to create exceptions, they have ways of doing it, right? They write, notwithstanding any other general or special law to the contrary. Here, you're saying they're creating an exception to the APA, but they don't say they're doing that, right?
I understand that. I hear that, Your Honor. I don't think that's the only way that the legislature can create an exception to a pre-existing statute, and where the ordinary...
Is there anything like this anywhere else? It seems like it's idiosyncratic.
I have to confess, Your Honor, I can't point the court to a statute that displays the same features the same way this one does. And of course, part of the reason for that is this really, I don't want to call it unique, but this really well-developed background context of the relationship between DHCD and local housing authorities. Section 7A was enacted against the backdrop of, West Broadway, Medford Housing Authority, this very, very robust oversight role for DHCD. As we argue in our brief, our view is that the best way to understand what the legislature was trying to do in Section 7A is force DHCD to wield this authority to review and strike contracts more vigorously, and also through the use of guidelines as opposed to regulations, give the department the ability to do it with some more flexibility, some more nimbleness. If executive directors start engaging in some sort of malfeasance that nobody had really imagined before, the department has the ability to change its guidelines promptly and address that squarely.
I know, but promulgate guidelines, first of all, they used the word promulgate, and there's no doubt that 7A contemplates that 7 exists and that you've got the Chelsea Housing Authority backdrop. Mm-hmm. But what is it about the text of 7A that says the APA and 30A is out for such a broad range of terms?
It's chiefly, Your Honor, the use of the word guidelines juxtaposed with the express authority in that third sentence that indicates that the guidelines are going to be they're going to be mandatory. They're going to be binding. Housing authorities are going to have to comply with them. Guidelines just kind of relies on the notion that when the legislature chooses a word, different words have different meanings in the statute. Guidelines suggest something different than regulations. We know that, in fact, in another section,
But isn't that a
121B.
problem for you? Because here, the agency has promulgated rules. Like, you must have a mandatory arbitration provision in your contracts with your EDs. Those don't sound like guidelines.
The way the department reads the word guidelines, and
Is as if it's a rule.
and we believe this is the way the legislature intended it, is the difference between guidelines and regulations isn't the scope or subject matter or content of what things can be addressed through that pronouncement, but rather the way that it comes into being. Regulations, as we discussed earlier, is a defined term in 30A Section 1. If something meets the definition of regulation, it has to come into being in a certain way in compliance with 30A. That's why the legislature chose the word guidelines, and if the court, you can see the statute cited in our brief.
I think your argument was better the other way, which is it's guidelines for executive director contracts. That's not sort of a traditional area of regulation where you go through a 30A process because the public, is super concerned about it. You're basically dealing with executive director contracts in response to a well-pronounced problem, which is Chelsea, it was a disaster. I mean, isn't that, I understand it's idiosyncratic, but the guidelines are connected to something narrow, which is executive director contracts. It's not like you're passing regulations for the entire way that the housing authority conducts its business. Because the public cares a lot about that. They care about what you're charging for rent and who gets in, but how much the executive director gets paid it's not really a public problem until we get to Chelsea.
Let me address that, Your Honor. It goes to something that I alluded to a little bit earlier, that in our view, there are really two reasons why the department complied with 30A here. One is that 30A just plain doesn't apply because Section 7A creates an exception. That's what I was speaking about earlier. But there's another reason, and the other reason is that these guidelines that are contemplated by Section 7A fall within that internal management exception to the definition of regulation under 30A Section 1. As Your Honor knows, I'm sorry?
Is that a fact question?
No, it's not, Your Honor, because what it really goes to is the nature of what the pronouncement does, similar to the way this court in Cary analyzed the Department of Correction pronouncement about dog sniffs. The appeals court, Judge Sachs, recently analyzed that DOC pronouncement about money transfers. It's not something that requires fact-finding and evidence. It's just something that requires analysis of the terms of the agency's authority, in this case, Section 7A, and how the scope of that authority fits with the definition of regulation under 30A Section 1.
Under your interpretation, how can we read Section 7 and Section 7A in harmony? Is that possible?
It is, Your Honor, and we think that in the Superior Court, Judge Connolly reached exactly the right harmony there by reading Section 7 to retain housing authorities' ability to set the terms and conditions, qualifications of employment within the limits imposed by the department pursuant to its authority under Section 7A. Now, in fairness, in some instances, like the arbitration clauses, the department hasn't left any discretion to local housing authorities. It said, hey, you need arbitration clauses in these contracts.
It's a little inconsistent with the shall determine.
I'm sorry?
It's a little inconsistent with Section 7's shall determine. And I recognize that 7A was meant to reform the bad old days, but I'm just wondering what's retained of Section 7.
We do think that certainly something is retained under Section 7. In some particular areas, like arbitration clauses, it may not be that broad, but in other areas, it certainly is broader. For instance, compensation. The DHCD sets maximum compensation. It doesn't tell local housing authorities what they need to pay these folks. And so returning, I guess,
Can you
to,
return to the internal management and discipline exception and tell us why this is more like the Commonwealth versus Tumble, if I'm saying it correctly, case dealing with the sobriety checkpoints as opposed to the prisoner cases and the public going into the prisons?
the key passage in Trumbull, Your Honor, we believe, is where this court wrote that the state police sobriety checkpoint handbook didn't purport to directly regulate the conduct of the public, and that quite squarely describes what these public housing notices, guidelines for executive director contracts are doing. They aren't regulating the conduct of the public directly, and we believe that Trumbull is on all fours with our position in this case. We know that matters like contracting are internal management, and fall within the scope of internal management. In fact, on that point, I would direct the court to the Associated Industries of Massachusetts case from the 1960s that indicated that workers' compensation insurance rates set by the commissioner upon a certain insurer's proposal are not regulations that need to be subject to notice and hearing because they only affect the rights of the insurer and those who choose to do business with them. Very similarly, the guidelines for contracts here only affect the rights of a local housing authority and those who choose to work for them. And so...
Is there any problem with the way you raised this issue in the litigation?
No, Your Honor, and, well, first of all...
This wasn't raised before Judge Connolly, right?
That's right, Your
Okay,
Honor.
so isn't that the problem?
That's our view, Your Honor. We don't believe that this was squarely argued or raised in the blue brief. If you read the blue brief, you won't see citations to Trumbull or Carey or any of the law in this area. Candidly, it was in response to this court's amicus announcement that we chose to put in an amended brief that did a full, thorough workup of this issue, and for that reason, we believe it is squarely before the court.